Ms Moss, Ms Murphy, if it's okay with you, I'd like to hear from Ms Jones next, just given us that we've heard the respondent's case so far. We may as well continue with that.
Very well.
Okay. Ms Jones. Ms Jones, would you like to affirm or swear on the Bible?
I'd like to affirm, please, sir.
Repeat after me then, please. I do solemnly, sincerely and truly
I do solemnly, sincerely and truly
declare and affirm
that
the evidence I shall give
shall
be the truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you. Ms Moss.
Miss Jones, how long have you been in your position within the respondent?
I've worked there for 5 years.
Do you remember the claimant coming to you in late November to report some conduct of Mr Moore?
Yes, I do.
She told you, didn't she, that Mr Moore had been speaking about a client when he had said she was well fit, I wouldn't have minded giving her one.
That is what the claimant alleged, yes.
And she also told you that when she told Mr Moore that she found his comment offensive, he laughed at her, said, "It's only a joke, love, don't tell me you're one of those feminists."
It was something along those lines. I can't remember the exact wording.
And you told the claimant when she came to you with these concerns that it was important for staff to let off steam.
In the context of those kind of jokes having been made before and no one had ever taken offence, and all members of staff participated in this kind of banter, men and women alike. So in that context, yes, I did make that comment.
Well, you say that, but there's no allegation that the claimant herself made these kinds of comments.
Well, there had been no complaint to date, so the claimant may have made that kind of comment in the past, but no one had complained.
But you were dealing with a complaint there and then at the end of November 2018, and what you told the claimant was that sometimes people have to let off steam.
I did say that, but equally I did act on that complaint. I spoke to Mr Moore about his comments, and I reminded him that he needed to be professional at all times.
Have you read Mr Moore's witness statement?
Yes, I have.
And do you accept what he says at paragraph 4, if I can take you to it? So it starts at page 57 of the judgment, of the bundle, and paragraph 4, at the end of that paragraph, Mr Moore describes that chat that you had with him at the end of November as brief, and he says that you were very understanding towards him. Do you accept that you were very understanding towards him?
Well, once Mr Moore explained that he had not in fact been talking about a client, as the claimant had understood that, but he was in fact talking about a celebrity, yes, I was understanding because, as I said, there was a lot of banter among the staff, men and women alike, and in fact, the claimant herself often referred to other male celebrities in very similar ways. So I didn't think that I thought it was just a misunderstanding, essentially.
Well, first of all, there's been no evidence at all that the claimant ever said words to the effect of, she was talking about a male celebrity, is well fit, I wouldn't have minded giving him one. No one's suggesting that the claimant participated in that kind of banter. You're not suggesting that, are you? That's not something you've said in your witness statement before.
It's not in my witness statement, no, but the claimant would have made those kind of comments.
You told Mr Moore at the end of November not to worry about Emily.
That's what my witness statement says, yes.
Well, I'm just going to interrupt you. I'm not very happy when witnesses say would have done something. What do you mean she would have? Did she do it or did she not?
Well, my evidence is that she did, although I can't remember a particular instance where she did that.
Okay.
And there's been no suggestion before by you, or indeed anybody else who's given evidence to this tribunal, that the claimant has ever participated in banter to the same degree as Mr Moore is accused.
I'm not entirely sure that's correct. Mr Moore has stated that the claimant took part in banter and made comments about the appearance of male celebrities.
Yes, that's as far as it goes. Certainly there is no allegation. What I put to the witness was that there was no allegation that the claimant herself had participated in the kind of banter that Mr Moore was accused of.
Forgive me, had Mr Moore said that before his oral evidence today? Is it in his statement?
It's not in his statement, no, sir, but I do think it is in the investigation statement to a degree.
Right, that's where I've seen it. Okay.
So it's on page 40.
Thank you. Let's just turn that up, shall we, briefly?
So page 40 says at the end, I have heard Emily and the other girls discuss in great detail how much they fancy Ryan Gosling and Brad Pitt, and Emily actually has a topless poster of Justin Bieber in her locker.
Yes.
Now, that isn't included, I think I'm right in saying, in Mr. Moore's statement.
No.
That's correct, but Mr. Moore did mention that the claimant had a poster of Justin Bieber.
Yes, I do recall that, yes.
Yes, I think he mentioned the poster, and he also said that the claimant had said that she found his appearance intriguing.
Yes, he used the word intriguing. That's fine. I mean, I don't see any problem with the questions, Miss Murphy, so let's continue, shall we?
It's fair to say, isn't it, that you were sympathetic towards Mr. Moore
At what stage?
at the end of November when the claimant first came to you making these complaints.
Well, the claimant came to me because of this comment, but she didn't seem particularly distressed or concerned. And I thought it was just a flippant comment. And I addressed it. I spoke to him. I reminded him that he needed to be professional. And he explained that it had been a private conversation with his colleague rather than talking about a client openly, as I initially thought that might have been the case.
Well, can I just interrupt, Ms. Moss? I'm sorry. Ms. Jones, what do you mean by professional if you'd already said to him in December you thought it was just a flippant comment? So I just want to try and understand what you mean by asking him to be professional.
Well, you're referring to the November incident rather than December. Well, I just meant that if, obviously, in the case where he was talking about a celebrity in a private conversation, I thought that was an acceptable comment. But I just reminded him of the need to be professional just in case he might, I don't know, in case he might talk about a client openly in front of other people, but that didn't transpire to be the case.
But as far as you're concerned, talking about a celebrity in that context was acting professionally, was it?
Well, and it was part of the level of banter that had gone on within the team, that had gone on for a long time.
I appreciate that that's what you said had been going on, but what I'm trying to get to, Ms. Jones, is what you say was professional. Was that professional, that banter?
Well, it wasn't unprofessional in the sense that it would have been offensive.
Understood. Ms. Moss, you may want to pick that up, but I just wanted to address that. Thank you.
Thank you. You say, do you, that you told Mr. Moore to be more professional in future during that conversation?
I did.
That's not something Mr. Moore suggests you said. Mr. Moore simply says that you were very understanding towards him and that you told him just to watch his language in future and not to worry about Emily.
I told him not to worry about this particular situation. I did not use the words, do not worry about Emily.
But it's also the case, isn't it? You didn't tell him to be more professional in future, because that's not something Mr. Moore remembers.
I remember using the word professional. Whether or not Mr. Moore remembers that particular word, I don't know.
You also say that you considered these comments not to be offensive when they were reported to you at the end of November.
Yes, that's right, in the sense that they were talking about a celebrity rather than a client.
But even if it was a celebrity, and you know that we disagree on that because it's the claimant's case that it was a client, but even if it were a celebrity instead, the words, she was well fit, I wouldn't have minded giving her one, those words are clearly, for the claimant, unwanted. Do you accept that they're unwanted words?
No, I don't accept that. In our workplace, this is just the kind of comments that would be made. It's a very high demand, very pressured environment, and this is just how the team like to let off steam. And as I've mentioned before, both men and women took part in this kind of banter.
So this specific comment you say was invited by the claimant?
I'm not saying it was invited by the claimant. I'm saying that...
Wanted by her?
I'm not saying she invited or wanted that comment.
Well, if it wasn't unwanted, she wouldn't have complained about it, would she?
I didn't take the claimant's complaint to be... it didn't come across to me that she was distressed or particularly offended by the comment.
It was related to sex, you accept that?
Yes, in the sense that they were talking about a female celebrity and her attractiveness.
And you do accept that it was related to sex?
Yes, I do accept
that. Yes. Presumably you don't accept that it caused an offensive environment for the claimant?
No, I don't.
Is it fair to say that you didn't really consider Miss Taylor in all of this, the claimant?
Well, again, I when she came to me, she wasn't particularly distressed. She wasn't particularly offended by that comment. She could have gone to HR, but she didn't. She came to me, and I told her that I would speak to Mr. Moore, and she deemed that to be a sufficient response. And so that's where I left it.
As a result of this conversation that you had with Ms. Taylor, you didn't initiate a disciplinary investigation, did you?
No, I didn't.
You say in your statement, it's paragraph 3, so I think your statement starts on page 52, and over the page on 53, you say, I would not hesitate to take disciplinary action, I think that's supposed to say, against team members where the banter goes too far, in particular where it is discriminatory in tone. I suggest that's demonstrably not true.
I would disagree.
You didn't arrange for Mr. Moore to work away from the claimant.
No, I didn't at that stage.
You could have, at any stage, you didn't arrange for Mr. Moore to work away from the claimant.
Well, I did ask the claimant whether she wanted to, at the investigation stage, whether she wanted to come in when Mr. Moore wasn't present. But prior to that, it just simply wasn't feasible. With our workload, the fact that we're a small team and, you know, in the run up to Christmas, things just get insanely busy. It just wasn't possible for me to have them in we don't even have 2 officers, so I don't know how that could have been implemented, really.
Well, you could have suspended him, couldn't you, pending a disciplinary investigation?
I didn't start the disciplinary action because I didn't think that was proportionate at that time. As I said, it was just a comment. The claimant didn't seem particularly distressed, and she seemed satisfied with the fact that I had spoken to Mr. Moore.
It's fair to say that you didn't dissuade Mr. Moore from harassing the claimant in particular, or women in general, at work thereafter.
I don't understand the question. Are you asking me if I'm encouraging Mr. Moore to discriminate?
You didn't dissuade him.
Well, I'm not sure if the witness can answer that question, to be fair.
I'll move on, sir. You did let Mr. Moore know that the claimant had complained about him.
Are we still on the November incident?
Yes, this is still late November.
Yes, I did when I spoke to him.
And yet you did nothing to protect the claimant from any victimisation, retaliation by Mr. Moore against her when she returned to work.
Again, the claimant didn't seem particularly concerned about maintaining confidentiality. She didn't seem distressed or worried about what Mr. Moore might think. She just wanted me to have a chat with him, and I did that.
Moving forward a couple of weeks, the claimant was absent for a couple of days between the 14th and 15th of December 2018, wasn't she?
Yes.
And she called you on the 15th of December. Yes?
Yes.
And she told you that on the 13th, so a couple of days before, Mr. Moore had asked her if she was going to the Christmas party, and he then said, maybe it will be your lucky night and I'll see you under the mistletoe. Do you remember her reporting that to you?
Yes, I do.
And she also reported that when she said, that's inappropriate, he said, oh, that's right, you're a feminist, aren't you? Probably a lesbian too, I know your type.
Yes, something along those lines.
And then she also reported that Mr. Moore stood between her and the door and tried to, and when she tried to pass him, he grabbed her and fondled her bottom.
No, the claimant didn't mention this. I asked her to tell me exactly what happened, and the only thing that she mentioned were Mr. Moore's comments, and there was no mention of any kind of physical intimidation or any part of that incident, really.
I suggest you're wrong about that. And the claimant did say in that conversation on the 15th of December that he had fondled her bottom. Do you remember her also reporting that he said to her, don't be shy, you know you love it, and then shouted the words, what a peach?
The claimant only mentioned the comments that Mr. Moore made. She didn't mention anything about fondling.
Well, that's not what Miss Moss is asking you about. She's asking you about the peach comment.
Yes, all the comments that you mentioned, the claimant mentioned to me.
You didn't, at that point, initiate a disciplinary investigation against Mr. Moore, did you?
No, I did not.
Even though presumably you accept that this comment was all the more serious, partly because it's a repeated allegation.
Well, I accept that the comments may have been, foolish and immature, but again, I didn't feel the need to take disciplinary action at that stage. What I told the claimant to start a procedure under our dignity at work policy, but I knew that there would be an investigation at that point, so I just didn't feel the need to raise any disciplinary action at that point.
You're not suggesting, are you, that the claimant wanted this conduct, invited this conduct?
No, I haven't suggested that.
And you're not suggesting, presumably, that these comments were not related to sex?
They were related to sex.
And these comments, clearly, at least certainly the allegation was, that they created an offensive environment for Ms. Taylor at work.
That is what the claimant alleges.
Have you read the dignity at work process of the respondent?
Yes, I have.
Then didn't you appreciate that this was an allegation of harassment, sex harassment?
Yes, I did. The dignity at work process document gives the definition of harassment, so yes, it's in there.
And again, what you say at your paragraph 3 of your statement, that you wouldn't hesitate to take disciplinary action against team members where the banter is discriminatory in tone, is simply not true. You certainly were hesitating, weren't you, Ms. Jones?
I disagree with that.
Well, you didn't ever initiate a disciplinary investigation against Mr. Moore in relation to these allegations.
I initiated the dignity at work process rather than the disciplinary action.
I'm sorry to interrupt, Ms. Moss. Can I just understand? Until now, I'd understood that the allegations in relation to constructive dismissal were that the claimant says the investigation should have been done differently, she should have been involved more, etc. But just so that I'm clear, are you saying as a positive fact in relation to the constructive dismissal case that the claimant is saying that failure in relation to doing a disciplinary was a reason for her resignation?
I think it's more of a general concern, really, on the part of the claimant, that her concerns weren't taken seriously as part of the grievance process.
Okay.
And a part of that is that there was no disciplinary investigation initiated.
Okay, well, we'll have to make a decision about that. It's not something that I'd understood to be pleaded, but I do appreciate that there's a general point in relation to taking things seriously. So please continue. I'm sorry to have interrupted.
Thank you. It's also right that the dignity at work process document from the respondent, which I think starts at page 61, suggests that paragraph 1.2, which is at page 62, that the respondent will not tolerate any form of harassment which occurs at work.
Yes, it says that.
And clearly the respondent in this case was tolerating this harassment from the end of November onwards.
I think I've explained a number of times now that I told the claimant she could bring a complaint under the dignity at work process. I did not take disciplinary action at that stage, but I knew that there would be an investigation in due course, so I don't think it's right to say that the respondent tolerated this kind of allegation.
Well, throughout this time, though, Mr. Moore was turning up for work and continuing as normal.
Again, I had yet to start the investigation, and I didn't want to take any decisions before an investigation had been done. I was just investigating, a few comments. There was no mention of assault at that point.
Ms. Jones, can you answer the question? Mr. Moore was turning up for work as usual throughout this process every day?
Yes.
And it was the claimant who was not fit for work as a result of what happened to her on the 13th of December. She wasn't fit on the 14th and 15th of December. Do you accept that?
She was signed off sick, so yes.
On the 19th of December, the claimant returned to work. Again, you did nothing to protect her from further harassment or victimisation at work.
Well, I've explained before, it's a very small workplace, and in the run-up to Christmas, there just simply wasn't anything I could do to keep Mr. Moore and the claimant from occasionally bumping into each other.
You don't dispute, presumably, what the claimant says, and that is that she suffered panic attacks and then became unfit for work due to the stress that the respondent placed her under, essentially.
I don't dispute that's the claimant evidence, but I never personally saw her having panic attacks.
In relation to the grievance procedure, when the grievance was received, you appointed yourself as investigation manager.
Yes, I did.
Despite essentially being a witness to the claimant's previous complaint.
I wasn't involved in any of the...
Sorry, I should rephrase that. I don't mean that you witnessed the incidents in question. What I mean is that you witnessed the fact that the claimant came to you with a complaint at the end of November. So she made a contemporaneous complaint.
Yes, as I was the claimant's line manager, she came to me for a complaint, but as you just pointed out, I wasn't actually a witness to any of the incidents that were involved.
But it's fair to say that you weren't an independent investigating manager.
Well, I'm an experienced line manager, and I'd like to think that I can remain impartial. And as far as I'm concerned, yes, I was independent because I wasn't involved in any of the comments that were made.
Despite knowing that the claimant was unfit for work because of stress and anxiety, you insisted that she attend a grievance meeting at the Respondent offices.
Well, when I initially started the investigation, the claimant was off sick, and then she remained signed off sick from work, so I wasn't able to interview her at work. So eventually, yes, I did ask her to come into the office so that we could proceed with the investigation. As I mentioned, I think a few questions ago, I said that Mr. Moore, I could arrange it so that Mr. Moore wouldn't be in the office to make that a more comfortable environment for the claimant to attend.
But you could have allowed, for example, for a telephone hearing to be undertaken or a video hearing without requiring the claimant to be at the office where these events occurred.
Well, I did try and contact the claimant by telephone. She wasn't returning any of my calls. She lives very far away from the office, and I just didn't have the time to go and meet her at her home. So I thought the best thing to do, because it had already been dragging on for quite a long time, the best thing to do would be to just get on with the investigation. And I thought, after all, I already have her side of things in the grievance.
But you denied her the opportunity to explain to you what her grievance was about.
Well, surely that's contained in her grievance document.
You did hear, nevertheless, from Mr. Moore and two other witnesses. You heard from them. You interviewed them.
Yes.
Ms. Moss, how long have you got left?
Only 5 minutes or so, maybe 10.
I was going to give you 5.
Thank you.
Try and stick to that, please.
You didn't mention at any point that the claimant could be accompanied to any meeting under the grievance policy.
No, I didn't.
The policy, the Respondent's policy, requires that the location of meetings are accessible. It's page 81 of the policy. It's fair to say that you did not make these meetings accessible to the claimant.
Well, again, I offered to make arrangements so that Mr. Moore wouldn't be present in the office, and that's again as much as I could do given our workload and the kind of environment that we were in. I mean, it was just, there was so much work going on that I just couldn't take 4 hours out of my day to travel to the claimant's home.
Did you read Mr. Tucker's investigation statement, the one that starts at page 44 of the bundle?
Yes, I did.
And notwithstanding the fact that Mr. Tucker says in his statement that the banter can get a bit out of hand, and he overheard Mr. Moore saying, "You're not a feminist, are you?" or words to that effect, you still failed to uphold the grievance against Mr. Moore.
Because I thought that was an appropriate comment in the context of this team and this working environment.
It's not right to say that you were an impartial investigating manager. You were somebody who had expressed your sympathy for Mr. Moore as opposed to the victim of this harassment right from the beginning, and that also pervaded your investigation of the grievance.
I disagree with that. Again, I'm an experienced line manager. I've dealt with grievance investigations before, and I know how to be independent when looking at evidence.
I have no further questions, thank you.
Thank you, Ms. Moss. I have 2 questions. Do you have any questions? No. You have any questions? Right. Ms. Jones, did you make a note of what the claimant came to say to you in December at the time?
I don't recall making a note.
I mean, they're pretty serious allegations, weren't they?
Yes.
And it didn't occur to you to make a contemporaneous note of what was said?
I didn't make a note at the time, but I wrote a letter to the claimant, I believe, a few days after, telling her to start the grievance procedure. So
you did, yes, yeah. And that's the second question I have, actually, in relation to that grievance procedure. Why not simply take what she was saying to you at that, when she came to speak to you in December, as the initiation of the dignity at work policy?
I was under the impression that in order to start the dignity at work policy, you had to fill in a specific form. I didn't realise that it could be as informal as just coming for a chat with me.
Okay, thank you. That's all I have. Miss Murphy, do you have any re-examination?
Just a couple of points. In relation to the first alleged incident in November, and I understand you have said that the claimant wasn't or didn't appear offended or upset about the comment. Do you recall what Mr. Tucker said as to how she reacted?
Sorry, when are we talking about, Miss Murphy?
At the end of November, in relation to...
I wasn't aware that Mr. Tucker was involved in that conversation.
Well, if Miss Jones took a statement from Bill Tucker.
Yes,
It's on
that's
page 44.
Page 44, yeah.
And if I can take you to the bottom of the page...
Yes.
I can't remember what Kevin had said previously that Emily had objected to. She just laughed at Kevin's comment, though, and I don't think she was upset.
That's contrary to Mr. Moore's evidence in the witness box, sir. Of course, we don't have Mr. Tucker as a witness.
It is, and we've got Mr. Tucker's evidence, however much weight we want to put on it. He's not here to confirm that, is he?
No, but Miss Jones interviewed him, and my question is, what was her response, having heard Mr. Tucker and Mr. Moore following that comment?
Okay, I see. Are you asking the witness whether she felt that Mr. Tucker was credible?
Well, yes, and how she formed her view that it wasn't a serious matter at that point.
Well, I mean, I'm not sure how much it's going to help us make our decision, but I'm happy for you to answer the question.
Well, my question is, did you ask Mr. Tucker about any comments made by Mr. Moore at the end of November?
Yes, I did, as part of the investigation into the grievance. And Mr. Tucker explained that the claimant had just laughed off his comments. And given that Mr. Tucker and Ms. Griffiths are both close friends with the claimant, I found their evidence to be credible.
Okay, thank you.
When the claimant came to you initially, and your evidence is that she didn't seem upset or too bothered, how did you respond?
In relation to the November incident?
Yes.
I was sympathetic, of course, but again, she didn't seem too distressed, so I thought it was just a minor incident, and I thought that having a conversation with Mr. Moore would settle the whole thing.
And did she seem satisfied with that response?
Yes, she was entirely satisfied that I just needed to speak to Mr. Moore, and she didn't want to take it any further, and I didn't think there was any need to take it any further.
Very well. Well, Miss Moss, you can ask that about the claimant in examination chief if you need to.
Yes, thank you.
And when, in relation to the December allegations, your evidence, as I understand it, is that the claimant came to you regarding some comments only. And again, just to be clear, how did you respond when she came to you in relation to that matter?
Well, again, I was very sympathetic, but at this point, it was nothing to do with an assault. I was just informed about the comments that Mr. Moore had made, and obviously it was the second time that this had happened. So that's when I told the claimant about the dignity at work process, and that she could initiate that if she wanted to.
Thank you.
I have no further questions.
I'm grateful. Thank you very much, Miss Jones. You are released.
Thank you, sir.